how to avoid probate in Florida. First, what is probate? Probate is a court-supervised proceeding that must occur in order for your assets to be distributed upon your death. It is often lengthy and expensive. Because of this, many of my estate planning clients wish to avoid probate. And in this video, I will explain why that is and how you can do it. To recap, probate is simply a legal procedure that is required before your assets may be distributed to your heirs, a relative who is entitled to your property if you die without a will, or to your beneficiaries, someone named in your will or other document who you designate to receive certain assets upon your death. The probate process can be long and complex. It requires filing documents with the court, and court hearings may sometimes be required. In fact, in most instances, attorney representation is required due to the nature of the proceeding. It's also not uncommon for families to wait 3 to 10 months to complete the probate process, which must occur before any assets are provided to beneficiaries or heirs. Florida law has established attorney's fees that are based upon a percentage of the estate's value. And in many instances, the fee may be as high as 3% of the estate. Another thing to keep in mind is that your estate is often required to go through probate, whether you have a last will and testament or not. Due to its often complex and costly nature, it is understandable that most people want to avoid it. But how? There are actually a few ways to avoid probate, some of which I'll discuss now. First, you can ensure that all of your assets are either jointly owned with the right of survivorship or list a beneficiary who receives the asset upon your death. Only assets owned in the decedent's name only are subject to probate. For real estate in Florida, you may have an attorney draft what's known as a ladybird deed, which provides you with ownership rights in your real property during your lifetime and passes the property to any beneficiaries listed on the deed upon your death and outside of the probate process. The main issue with some jointly owned property or a ladybird deed is that the asset may be subject to the claims of creditors of the joint owners or the beneficiaries on the deed, which is a risk that should be discussed with an attorney prior to taking steps towards owning property this way. Potentially a more popular way to avoid probate would be to set up a revocable trust so that your property and other assets may be owned by the trust, then distributed outside of probate upon your death. You can even be the sole beneficiary of the trust during your lifetime, with the ability to pass all remaining assets in the trust to your beneficiaries in a discreet and stress-free manner, often without a bunch of added time or expense. Depending on which state you live in, there may be other ways to avoid probate as well, so it's important to meet with an experienced attorney who will help you to navigate an estate plan that's right for you. As always, I hope this helps.